We're very fortunate to have with us today two esteemed guests, Jesse Eisinger, a Pulitzer Prize-winning author and journalist, and John Arterberry, former Executive Deputy Chief of the Fraud Section in the Criminal Division of the Department of Justice. So for the next half hour or so, Mr. Arterberry will first introduce and then interview Mr. Eisinger about his new, highly acclaimed book, the subject of that. And this is the book. It's called The Chicken Shit Club, Why the Justice Department Fails to Prosecute Executives. And believe me, it is a good read, although it will make you angry. So there should be 10 or 15 minutes left at the end of their discussion for questions from the audience. So if you could hold your questions until then, that would be great. And we're going to end promptly at 1 o'clock so that all the students and faculty in the room can get to their 1 o'clock classes. I'd also like to extend a special thanks before we get going here to all of the staff that made this possible: Quenna Stewart, Brandy Drinnen, Grace Renshaw, Robert Dorsch, and all of the students and faculty that helped put this together. So before I turn the mic over to Mr. Arterberry, let me tell you just a little bit about him. After graduating from this law school in 1973, John Arterberry worked for the SEC, in the enforcement department there, for about 7 years, and then he moved to the fraud section in the criminal division, where in 32 years he became a legend. He worked first as a trial attorney and then eventually as the executive deputy chief of that section, winning many awards for all of his accomplishments over those years. The department named its annual award for professionalism after him, and it recognizes a member of the fraud section each year for, quote, commitment to upholding the department's highest ideals of professionalism and integrity. It's nice to have that kind of award named after you. You should all aspire to that, you people out there. We are very lucky to have him here back in the law school community, and we're grateful for his efforts in helping to bring Mr. Eisinger here today. Please join me in welcoming John Arterberry.
Thank you, Professor King, for that was too much of an introduction. It's terrible to get big build-ups like that, but it's great to be back at the law school. And it is, I have to and this is not going to be a surprise, but it is a huge thrill to be able to visit today with our guest about this book. Our guest, as Professor King said, is a Pulitzer Prize-winning journalist. His reporting, his investigating reporting has focused on Wall Street through most of his journalistic career. His works have appeared in the Wall Street Journal, the New York Times, a host of publications. And in some ways, I think, Jesse, your work really culminates in, I have a biased view here, but I think in this book. And I'm looking forward today to talking to you about it and learning, and I think sharing with everybody here the things that you uncovered and some of the insights you can share with us. So at this time, Jesse, if you will join, please welcome Jesse Eisinger here in the law school. There's a very easy way to start this conversation, Jesse, and that is, what's the story behind this title?
Gotcha. Yes, that's very frequently the first question, and first I'll say thank you very much. It's an honor to be being interviewed by you. The way I did this book is to interview people like John, including John. So I feel a little foolish now with the shoe on the other foot, although I'll see firsthand what it's like being cross-examined by former federal prosecutor. I'm sort of looking forward to it, but we'll see.
This will be soft.
Thank you, Nancy, for bringing me here, and thank you all for coming. I'm amazed that you guys showed up. I'm hoping you weren't getting paid or anything like that. Don't tell me if you were. But so the title is, I have 2 daughters, 8 and 5, and so the title is very popular with them. Therefore, much less popular with my wife. We went to a dinner party a few months ago, and all the kids went out to play in the backyard, and suddenly we started hearing, "You say chicken, I say shit." The kids were shouting the title of the book, and my wife just sort of put her head in her hands. I don't think we're going to be invited back. So very quickly, I don't want to filibuster because we'll get to substance, but so in 2002, Jim Comey, the guy who was just fired as FBI director, becomes the U.S. Attorney in the Southern District of New York. And the Southern District of New York is the best office in the land, in the DOJ, and the way you know that is to ask any alumni of the Southern District. They will assure you of that. John might disagree. And they certainly think of themselves like that, and they think of themselves as the best trial lawyers in the country, and of course many of them are. So Jim gives a speech after a few months, and he to all the criminal prosecutors at the monthly meeting, and he before he starts his remarks, he says, "How many of you have never lost a case?" And a bunch of these go-getters' hands shoot up because they're very proud of their record. And you have to understand, these people are really the best of the best. They've gone to law schools like Vanderbilt, but before that, they went to the best colleges in the country, and after that, they clerked for the best judges, and they've achieved this this pinnacle, and along with the Southern District and the Eastern District of New York and EDVA and Maine Justice, these are among the best offices in the U.S. Attorney's offices in the country, and they're very proud, and they shoot up their hands. He says, "Well, so me and my buddies have a name for you guys. You're the Chicken Shit Club." Hands go down. They sort of slump in their chair. What was he talking about? Well, what he was saying is your job isn't about winning. Your job is about justice. And that means that you're not taking on the low-hanging fruit. You are trying to identify the most meaningful cases, the most ambitious cases. And you cannot be afraid of losing or trying to preserve your pristine record. You have to go out and take on the powerful when they've done wrong and try to bring justice. And that's what your job is. And unfortunately, my argument is that over the next 15 years, after he gives that speech, the Department of Justice writ large becomes the Chicken Shit Club. It loses the will and ability to prosecute top corporate executives. And we'll get into that, I assume, in the conversation.
We will. First, Jesse, what led you, and I think we can begin to sense the answer to this, but what led you to take on a topic like this with the research that it required?
Yeah, well, as you said, I covered Wall Street my entire career. And I was covering the financial crisis before it happened at the Wall Street Journal. I was covering the housing bubble and seeing it sort of start to happen and kind of identifying it. And I left the Journal in 2006 to go to Condé Nast. They launched a glossy magazine called Portfolio. And I thought no one is going to be stupid enough to launch a glossy magazine again, so I should see what this is like. And I was there, and I wrote about the bubble and derivatives, the problem of derivatives, and I kind of, not getting it completely right, but sort of kind of sniffing around the big problems. Then, of course, the financial crisis happened. The magazine closed. I was lucky enough to be recruited to ProPublica, which is a nonprofit. We do investigative journalism. It was started by the former managing editor of the Wall Street Journal, which is where I had been. And I it was the biggest moment of any business journalist's career, the biggest cataclysmic event, the financial crisis of 2008. And a colleague and I wrote about the mortgage-backed securities called collateralized debt obligations, which were really the heart of the crisis. That's what we were fortunate enough to win the Pulitzer for. And then after we had identified that wrongdoing, and after many other reporters had identified what I considered to be significant wrongdoing, we waited for the indictments, waited for the SEC and the DOJ to start cracking down and hold people accountable. And it never came. And it was a terrible puzzle to me. And I started writing a little bit about it. I wrote a column about it for the Times. Other people wrote about it. And then I finally was it was such a mystery that I wrote a piece for the New York Times Magazine. And then I thought there really is something more here. And so I launched the book to try to solve this inexplicable mystery. And this is the attempt to explain it.
Jesse, your book, though, doesn't begin with the financial crisis of 2008. It actually begins with what we call the Enron era, the Enron constellation of cases back around the turn of the century. Why did you start there?
Well, because this is not a problem with the banks, and it's not just a problem with the financial crisis. My argument is that this is a problem that was building before the financial crisis and persists to today, and it doesn't just involve the top executives from the biggest banks, but it involves top executives from the biggest companies in America. So we can't prosecute retail executives, CEOs, and tech executives, and industrial executives, and pharmaceutical executives. So what I wanted to do was kind of try to figure out the historical context from this. And I looked back at the Enron era because this was a time when we used to do this thing. We could prosecute top executives, and it wasn't that long ago. And so I wanted to kind of try to understand the differences, because I say this in the book, there's never been a golden age where we prosecuted the rich and powerful very well, but there have been silver ages, and the last silver age was the Enron era, where we prosecuted the top executives from Enron, WorldCom, Adelphia, Tyco, Global Crossing. There's almost every major accounting scandal from that period of time, we successfully prosecuted the top executives. And so I wanted to do a case study. I thought it was a riveting story. I hope people who read the book will agree, the Enron prosecution. And the most important thing that I found, at least to me, was that to the extent that anybody remembers Enron in this room, many of you are young, but most of us remember Enron as an obvious fraud, and probably then therefore think that the prosecutions were inevitable. But there was nothing inevitable about getting the CEO and the chairman, Ken Lay and Jeff Skilling, of that the company. They didn't put anything stupid in email. They hadn't written a lot in memos. There were no wiretap, so there was no direct evidence. There was that case had to be built the old-fashioned way, and that's what I sort of walked through in the chapter of the book.
Well, if we can call this the Silver Age, as you wrote the book, what did you find that you think helped the department and its prosecutors succeed during that time?
So, a wide variety of things, because I think this is a multifaceted problem, and there's no sort of silver bullet solution to this. And it, to skip ahead for a second, the problem is not that Tim Geithner gave a call to Eric Holder to lay off the banks. This is, so it was not, in my view, a conspiracy. So what happened in the Enron case specifically? Well, one thing we did was we devoted enormous resources, adequate resources to it. Something that we did not do, the federal government did not do in the wake of the financial crisis, which I consider to be a great scandal. So there was a team drawn from around the country of FBI agents and prosecutors solely dedicated to the Enron prosecution. They were locked in a room, not literally, although it felt literal to them at many times. And then they were given the political cover and the bureaucratic cover to work on this case solely. And that's very important. So,
What do you mean by that?
well,
Cover.
yeah, well, cover or encouragement or George W. Bush, a president whom I do not admire in many ways, was essentially, faced an enormous amount of political backlash within his White House administration when it became apparent that his Department of Justice under John Ashcroft and the Deputy Attorney General Larry Thompson were aggressively starting to investigate all these executives, including the Enron executives who were major political benefactors to the Bush family and major figures in Texas Republican circles. And Ashcroft had connections to Enron. And so there's a lot of pushback. And Larry Thompson, the Deputy Attorney General, who I admire greatly, is one of the heroes of the book, and a guy who you may have heard of, then the head of, sort of obscure figure, head of the FBI named Bob Mueller, are brought to the White House because there's this kind of, these political operatives in the White House who are angry at the aggressiveness. And Larry Thompson and Mueller present the evidence that they have. They sort of do a serious kind of accounting of the wrongdoing at these companies, not just Enron, but the wide variety of companies that the DOJ has the investigations going into. And to his credit, enormous credit, Bush says, LT, go ahead, you continue with this, and gives them the political okay. Now, who knows what would have happened? Would the DOJ have gone ahead with the investigations if he said I was troubled or if he communicated some kind of, I don't know. I mean, the DOJ should be independent. But that was, I think, an important step. So that's what I mean by political cover. And then kind of bureaucratic cover was that the Enron task force was given some resources, not always adequate resources, a lot of warm bodies. The people were dedicated solely to this job, and they screwed up a lot. They lost some cases. One of the things that they screwed up, I actually am trying to rehabilitate, which is the Arthur Anderson prosecution, which actually was, which we can get into in a second. But they lost some cases, and they were never disbanded because they lost cases. And one of the things that's absolutely incredibly important, that goes back to the Comey speech, and that is a kind of lost understanding, is that sometimes you lose these cases. These cases are highly complex. You're going up against the best defense. I'm talking about white-collar cases against well-funded top executives or former executives from major companies. They have the best defense lawyers in the country. And white-collar cases are very difficult to prove. You have to prove intent. In proving intent, you need to have witnesses or you need to have damning evidence. These cases are often revolve around complex things that seem kind of gray or seem like judgment errors. And so you are going to lose cases. And there has to be a kind of institutional willingness to take risks and occasionally lose and suffer the bad press and suffer the short-term career consequences from that. And instead, it's the opposite. They're afraid and they don't want to suffer those consequences internally or for their future.
And as your book makes clear, during this so-called Silver Age, despite some setbacks, the department did achieve a string of very impressive convictions of top executives.
Right.
So I think it's a fair I think it's a fair label to put on it, the Silver Age. Let's move the timeline forward to the advent of a new administration. The Obama administration arrives in Washington. At the same time, this is the period when the crisis, the financial crisis, is beginning to have severe effects on our economy. And the leadership changes, as it does every new administration, at the Department of Justice. Your book really gives us, I think, a detailed picture of how that new administration and the leadership began there at the department.
Yeah, I hope it's not too detailed, the blow by blow of each bureaucratic machination. Well, so we'll skip the period, but I'll just very briefly sort of say that, you know, this isn't just the Obama administration's fault, or Eric Holder or Lanny Brewer's, you know, that they're not solely to blame for this problem, although I do blame them and I'm critical of them. But so this is building in the wake of the Enron prosecutions, the Enron era prosecutions. There's a huge corporate and white collar defense bar backlash against those prosecutions. They argue that the DOJ has been overly aggressive, that prosecutors have been cowboys, that they're criminalizing bad business mistakes, and they roll back a series of, they have a sort of series of victories, sort of political victories, lobbying victories, rolling back policies from the DOJ. The DOJ doesn't help itself by screwing up a bunch, and so particularly in the Ted Stevens case, the senator from Alaska, where they've where a judge rebukes them, and so culturally, the Department of Justice is kind of a mess when the Obama administration comes in, and is reeling from a series of problems and scandals. So the first Bush administration under Larry Thompson, the first Bush DOJ under Larry Thompson, that kind of regime, I have great admiration for. By the time after it's gone through the Gonzales regime, the Gonzales DOJ, they've had the period where there was the U.S. attorney firing scandal, and they've installed some apparatchiks who kind of purged people in the at the DOJ, and it's kind of reeling. So the Obama administration comes in, and Holder comes back to the DOJ after serving time at Covington and Burling, the Washington power law firm, and they really sort of think that they have to clean things up. And my argument would be that they over-interpret the amount of the seriousness of the problems of the DOJ, and they start cleaning up, you know, your area, and you know more about this than I. You know, they start sort of focusing on the fraud section, and they have an ethos. So it's the Holder regime, and they've got another guy from who's the Deputy Attorney General, David Ogden, who I admire. I think he's a very thoughtful, intellectual guy. He has virtually no criminal prosecutorial experience. And then they put Lanny Brewer in charge of the criminal division, also a guy with virtually no criminal prosecutorial experience, especially on the federal level. He'd been a DA under Robert Morgenthau in New York a long time ago. But really what he was a defense attorney, corporate, high-profile political figure in the Clinton White House. So they don't have criminal experience. They don't have much white-collar prosecutorial experience. They're focused on kind of cleaning up and professionalizing the DOJ, and what they mean, what they think of when they when they're talking about professionalizing it, is importing a kind of defense bar, private practice, big law firm culture, which is absolutely anathema to a proper prosecutorial office. They're literally from the other side, and you know, absorbing the lessons from the other side. It's the wrong thing.
Without getting too much detail, when you say it's anathema, what's the big difference between what you want to see in a prosecutor and a well-run private firm?
Well, that's a good question. The prosecutors need to specialize in ultimately pissing people off. If you're a prosecutor, you need to be focused on depriving someone of his or her liberty, ultimately. And you need to do that judiciously. The power of the federal government is awesome, even when brought to bear on a CEO or a billionaire who's adequately resourced, and it can be abused. But ultimately, you need to focus and work to focus on individuals who have committed crimes and put them in prison. And in doing so, you're going to upset a lot of people. If you are coming from a defense firm where you have defended these type of people, and if you have come through a kind of elite education where you have gone to the best schools throughout your life, and you've figured out what society wanted from you from the very early age, and achieved that, figuring out exactly what society was asking from you, and achieving those things. When you get to become a prosecutor, those are not the skills that are being asked of you. It's a different skill to really specialize in discomfort and pushing. And all the incentives are for you as a prosecutor now not to push to, not to be a person of you want to be the incentives are to be a man or woman of proportion, to be ultimately reasonable. And so ultimately that means sitting down and negotiating with the people on the other side of the table, the defense, the defense team on the other side of the table. And then the other incredibly damaging and dangerous thing here is that those people are your future employers. Now, I don't think that the revolving door is the only problem here, but it is an enormous problem. And so the culture of the Department of Justice now is that it is a training ground for young prosecutors who are eventually going to be partners at corporate defense corporate defense firms at the best firms, getting paid an enormous amount of money.
And we'll come back to, I think that there is a theme in your book where we see in a large picture some of the things that I think exist today that you found result from this succession of changes in how the department and its prosecutors do their jobs. But as the new administration, as new leadership at the department continued to take hold, what about the casework?
So the administration makes a bunch of mistakes. And one of the things that they do is there's a lot of kind of infighting, bureaucratic infighting. It's very bad luck that the financial crisis hits at the very tail end of one presidential administration and the beginning of the other, because there's kind of inevitable ramping up getting the appointments in place. So Lanny isn't in place till, I'm going to go on memory, but something like April, and Preet Bharara isn't in place in the Southern District until...
And Lanny is Lanny Brewer, who heads the criminal division.
Yes, Lanny Brewer heads criminal division, and Ogden is not getting along with Holder, so there's a lot of bureaucratic infighting. One of the things they do is they consider a task force like the Enron task force to head up the prosecutions for the financial crisis, and then ultimately kind of reject that idea, that kind of a kind of operational task force where prosecutors can really get together and work, drawn from all around the country, and then work on the specific cases. And instead, they end up in the late 2009, I believe, although I might even be a year off. They end up with a bullshit bureaucratic exercise called the FFETF, which I can't even remember, the
Financial Fraud Enforcement
Task Force, which is just a kind of check the box meeting where with 98,000 members and no one in charge of it. That's a colossal mistake. And
just to make sure we're clear about this, even though it was called a task force, as you pointed out, there are task forces that, like the Enron task force, that they take on cases. They investigate, prosecute cases. This was not an operational task force. It was more of a senior working group, I guess we could call it.
Right,
that
a senior meeting group.
Yeah.
Where people sent their assistants to check the box that they'd attended the meeting, essentially. So a big mistake. And then, of course, they're very worried about the fragility of the system, the financial system. So they don't. They're not pursuing these prosecutions very aggressively because of this fear, which I think was terribly misplaced for a wide variety of reasons.
But early on, there is a case that's brought in the Eastern District of New York.
Right. Then there's also one of the early cases. So without the task force in place, and without a strong deputy attorney general, the deputy attorney generals in the Department of Justice. Let me back up because some of you may not understand. Of course, you do, but the Department of Justice is a bizarre bureaucratic entity, a bizarre federal agency because it's 94 offices around the country, and U.S. attorneys mainly consider, they have two jobs. One is to prosecute crime, and the other is to ignore Washington. And
by that you mean Main Justice.
Right, and by ignore Main Justice, exactly. Any dicta that come from the Attorney General, the Deputy Attorney General, they feel like it's their job to tell them to fuck off. And
each U.S. attorney is a presidential appointee confirmed by the Senate and fireable only by the president.
As we know, yes, by the president, exactly. So they have a lot of autonomy, and they jealously guard that. And then even within the offices, each assistant U.S. attorney is very entrepreneurial about his or her cases. So it's very hard to herd this organization. And you need a powerful and savvy and politically minded deputy attorney general to do that. And Ogden, for all of his skills and talent and intelligence, was not that guy. And none of the deputy attorney generals, maybe until Sally Yates, was really up for this kind of job. And by the time Yates came in, it was too late for the financial crisis. So that's that's problem number one. So they're left to their own devices, and the EDNY, the Eastern District in Brooklyn, brings the first case against two hedge fund traders or hedge fund managers at Bear Stearns, and they lose the case. It's poorly prepared, it's poorly tried. They are overly confident about their evidence. And here I'll just have a side note that the Department of Justice prosecutors have become overly dependent on a certain kind of evidence and have lost the ability to generate other kinds of evidence. So they're very, very interested in developing direct evidence of stupid emails. Like they build cases on stupid emails.
Smoking emails.
Smoking gun emails where the participants have said something, where you directly have said something that's very incriminating. The second thing that they like is wiretaps. So that's what the Southern District, pre-Barrara, focuses on, wiretap evidence in prosecuting insider trading cases. I'll get to that in a second. So they develop these cases based on evidence, like email evidence. They eschew these other skills and ways of proving cases. They it turns out that the email evidence is very easily, in this case, sort of disputed because there are other emails that say different things, and the defense attorneys cloud the picture and the guys get acquitted. And that sends cascading ripples throughout the Department of Justice because they are, as we have said, very afraid of losing. Both on an individual prosecutorial level, people feel like their careers within the department will be damaged if they lose cases, and then they feel like their future prospects, employment prospects, will be damaged if they lose cases. So that you need really strong leadership to accept losses, and the first loss was very damaging. Meanwhile, over in the Southern District, which really is the premier office for prosecuting financial crimes, right in Preet's backyard, he's looking somewhere else. He's looking at insider trading cases.
Why?
Well, because they're easier to prove, and one, juries understand them, prosecutors know how to bring these cases. The evidence, as I just said, is incredibly tantalizing, and these prosecutors are human beings. They had evidence of, one prosecutor was telling me, I was inside the room, listening to these asshole hedge fund guys plot their crimes and destroy evidence in the middle of the night, like going out and breaking up your cell phone and throwing it into garbage trucks around Manhattan. It's extraordinarily exciting, sexy stuff. Or I could look through the 300-pound CDO prospectus to figure out whether there was a crime committed. What am I going to naturally gravitate to? And so with these entrepreneurial prosecutors, they're sort of gravitating naturally to the stuff that's a little more sexy, where you can get on the cover of the Wall Street Journal and you get your little stipple image. When you're going to parlay that into a $1.5 or $2 million partnership at a law firm, or you could toil on CDO cases where you don't know if there's a crime committed. That's where leadership comes in. That's where Preet should have come in. But Preet is winning these cases. And he's becoming a star. He's the only superstar prosecutor that we have in this country these days, or one of handful. And so he loves winning these cases. His office runs up a record of 80-0 in insider trading cases. Meanwhile, he's totally neglecting this extraordinary calamity that has immiserated millions of people around the world, that speaks to systemic problems and corruption at the heart of the global economy. And he's off doing insider trading cases, which I really argue is a kind of total non sequitur.
And your book makes the point that the cases, and there were some cases out there, potential cases in U.S. attorneys' offices, again, because of what you identify as the lack of strong leadership at the top, the coordination, the refereeing, that is, which district gets to do which case, that doesn't happen. And those cases, I guess in your words, just die on the vine.
Yeah, I mean, I think it blows my mind that there was no one person in charge of, who had responsibility for overseeing financial crisis cases, one. And there was not a single prosecutor whose sole responsibility it was to prosecute financial crisis cases. So the person who was looking at Lehman Brothers, the collapse of Lehman Brothers, and there were 2 or 3 people in the Southern District, also had a full plate of other cases, 4 or 5 cases at a time, complex cases. So you're meant to, and by contrast, the bankruptcy examiner, Jenner and Block, that works on the excavating the Lehman Brothers bankruptcy, devotes thousands and thousands of person hours to this and has dozens, I don't remember the numbers are in my book, but dozens and dozens of partners and associates and lawyers on this case to figure out what happened excavating, and they write a multi-thousand-page report on it. So, those prosecutors need the resources and time and bureaucratic protection to investigate these things, and they didn't. So, one of the things that Lanny Brewer will say if you ask him, or most of the prosecutors, or Eric Holder, if you ask them, they'll say, I never saw evidence of a crime committed by a banker in the financial crisis. If I'd seen the evidence, we would have prosecuted. We don't shy away from this. This is what Preet Bharara will say. And my answer is you didn't look. And so it's not surprising that you didn't see it.
As you point out, you call it the culture of, or an aversion to not losing, the amorphous leadership that the FFETF was ostensibly providing. We go through this period with no real individual prosecutions, but there is the advent of settlements.
Yeah.
Is that an answer? Is
Yeah.
that a good answer?
So it's a. I think we call it, they, in lieu of prosecuting individuals at the highest levels of corporate America, now the Department of Justice settles with corporations for money. From 2002 to today, they've done over 420 so-called DPAs, deferred prosecution agreements, or non-prosecution agreements, versions of settlements. In the previous decade, 92 to 2002, they'd done 18. This is the preferred way that we enforce laws against corporations in America today. We settle for money. It is woefully inadequate. I argue, it's a terrible scandal. The first thing is that the executives don't pay out of their pockets. They pay with shareholder money. Usually, the stock price goes up upon settling with the government because investors are very happy that this has all been resolved. No big problem. There's very little. Not only is there are very few individuals who are ever charged in any of these DPAs, but they're often not even named in the finding statements of facts. And while they're ostensibly supposed to be a prelude to then going out and prosecuting individuals, in fact, as part of them, almost inevitably, they say, this is predicated on your continued cooperation with our further investigations and prosecution of individuals. Almost no individuals are ever prosecuted in the wake of a DPA. So actually, DPAs are the end. And this is an extraordinarily corrosive system. It does not hold individuals accountable. It does not work. And the reason why I say it doesn't work, the evidence is clear, is that we see recidivist corporations. We see corporations like JP Morgan Chase or BP or Pfizer entering into settlement after settlement after settlement. Pfizer's entered into every kind of settlement possible. They've had a subsidiary plead guilty to crimes. They've entered into a DPA, which is technically admitting that you've committed a crime. You've had a non-prosecution agreement, which is like a subtle gradation below that. But they still keep doing it. So it doesn't work. And I argue that prosecuting individuals does work. That does deter crime.
And in the Enron era, the deferred prosecution agreement, the DPA, was not a settlement tool, but it was the first step. It was used to gain the cooperation of the corporation, because the corporation can be a big shield against effective investigation. So the DPA gave the prosecutor a window into the corporation, gained the cooperation of the corporation to go after individuals. But we've kind of taken it 180 degrees, and now it's the basis for settlement.
Yeah.
And that's where we end.
Yes, I am a big critic of the kind of cooperation regime that the government has set up with corporations.
Well, and let's look at that, because if we say what's the picture today and what are the continuing challenges, one of the things you talk about is this symbiotic relationship between big law and the department.
Yeah.
What do you mean by that?
So the kind of modern cooperation regime with corporations dates back to the 1970s with Stanley Sporkin, who was the director of enforcement at the SEC, realizing that the SEC had very few resources and he wanted to leverage the power of the government, so he had identified that corporations were bribing officials overseas in a kind of pandemic of corruption, and so he sets up a big cooperation regime where you were part of it, and it's incidentally very flattering that you were actually part of a lot of things that are in my book, and you continue to speak to me. So it sounds to me that I got some things kind of right. So the it takes a lot. Personnel is policy, so it takes the right kind of leadership. Stanley Sporkin was willing to make enemies, and this kind of this initiative, this kind of new way of getting corporations to cooperate for leniency was a good idea at the time, but now it's been corrupted. And it's been corrupted, one, because big law has realized that this is an enormously lucrative business. And the business of internal investigations for your corporate clients is a wonderful line. Highly lucrative, very high margins. One of the wonderful things about it.
How much has Walmart paid for its most recent?
Geez, yeah. Now you're going to test me on
Well,
numbers, and I put it in the book. Now I
Yeah,
can't even.
upwards of $700 million.
So, yeah, these are extraordinary. The wonderful thing about this business is that you go to your client and you say, "Now I just want to tell you." We're going to ask you to look into things, and you should never tell us no. Don't tell us that we can't take this trip or interview that person, because if we have to tell the government, when the prosecutors ask, has the client ever not, has the client ever prohibited you from investigating a certain line of inquiry, or that'll be very damaging for you. So you better give us a blank check. So this is a really sweet business. And 40 years ago, the biggest law firms in the country did not do white-collar criminal defense. That was beneath them. It was the kind of stuff that the drunk lawyers on the other side of town did in Washington, D.C., and the kind of boutiques did it in, not the white shoe firms, did it in New York. And over time, big law has realized that this is an extraordinarily lucrative, interesting business to be in.
Let's get in, we'll get into more detail in the remaining time, but we do want to have some questions here from our audience. This is a great opportunity to ask the expert here. So question, I think if you just stand, so we'll start over here, first hand. Yes.
Yes, so I'm Professor Blair, and I teach about some of these things, and one of the things that's striking about what you've said so far, and I haven't read your book, so I apologize if it's laid out in there, is that you talked about why they didn't prosecute, but I haven't heard you name a crime. What crimes were committed that should have been prosecuted?
Sure. It's okay that you haven't read my book. I just asked everybody who knows me that they buy my book. I think that there dozens and dozens of bankers should have been, could have gone to prison, could have been prosecuted for a wide variety of crimes, and I'll answer. So the book is not a legal brief. I'm not a lawyer, and I didn't set out to sort of try to prove beyond a reasonable doubt a particular crime. What I wanted to show is the culture of the place and why these prosecutions don't take place. But I think that the big banks have already admitted that they serially misrepresented what was in mortgage-backed securities when they sold them to investors. I think that they've signed DPAs with that. They've also had civil settlements on those things. I think those could have been criminal. I think individual bankers could have been held criminal. I think that individual bankers and traders could have been held criminally liable for lying about the value of the assets. In fact, one of the ways that you can refute any prosecutor saying there were no crimes committed in the financial crisis is to mention the name Kareem Sarah-Geldon. Kareem Sarah-Geldon is the only guy who went to prison for the financial crisis. I wrote about him in the New York Times Magazine piece. He's not a big figure in the book, but he was a kind of mid-level executive at Credit Suisse First Boston who oversaw two traders who lied about the value of the assets on the books, their residential mortgage-backed securities, RMBS. Now, there's nobody on Wall Street who will tell you that those two jokers were the only two guys to lie about the value of their mortgage-backed securities in the wake of the financial crisis that involved mortgage-backed securities and CDOs. So so they could have prosecuted for that. They could have prosecuted for misrepresentations on the CDOs, building CDOs to fail. They could have prosecuted the top executives for lying about the books and records and the value of their assets and misrepresenting that. So I think that there could have been dozens and dozens of cases.
Another question.
So you had mentioned that a major problem with the system is that prosecutors are often prosecuting future employers. A lot of that's driven by the fact that government salaries are pretty low for the experience they have compared to the private sector. The SEC has seen some success in giving special dispensation to raise salaries for their employees to keep them. Do you think that DOJ could benefit from a similar program of receiving a special exception to increasing their employees' salaries and increasing compensation in order to retain talent?
Yeah, so one of the reasons why I think prosecutors should love my book, even though I'm very critical of them, is that I advocate that we should jack up their salaries hugely. Because what I want to do is, the government's never going to be able to compete with the private sector on a one-to-one basis, but there are a lot of people who don't want to go into the private sector. A lot of great civil servants who want to spend their whole careers in serving the public. And so I think that highly educated people who want to serve the public should be able to live affluent lifestyles in the most expensive cities in the country. So you pay prosecutors $450,000 a year. This is never going to happen. Congress is never going to allocate this kind of money for them. But if we had those kind of salaries, you could live an affluent lifestyle in New York or Washington, D.C., and serve in the government, and you blunt the inevitable attraction that these very high-profile, high-paid partnerships at law firms would
Time for one more question.
Yeah.
Yeah, you mentioned Arthur Andersen just briefly, but I'm wondering if any of the major accounting firms still in existence, with their auditing departments, with their consulting divisions, whether that's, that might be contradictory in and of itself, but could they be held accountable for that, and are any individuals of those firms deserving of prosecution?
30-second answer.
30-second answer. Okay, we're going to get out. I think the Arthur Andersen prosecution was the right thing to do at the time. I think that I haven't looked at the specific accounting firms in the wake of the financial crisis, but I would say that one of the secrets to adequate white-collar policing and deterrence is to prosecute the gatekeepers. So you prosecute the lawyers, the bankers who enabled corporate fraud, and the accountants. And that's what Robert Morgenthau did in the 1960s as Manhattan DA. That's what Sporkin specialized in, albeit not criminally, although occasionally criminally, in the SEC in the 1970s. Prosecute the gatekeepers.
There's much more that Jesse Eisinger talks about in his book. He identifies the heroes, people like Judge Jed Rakoff, Stanley Sporkin, the role he played, Larry Thompson, the leadership he provided at the department, and individual prosecutors, people like Paul Pelletier, and we could spend an afternoon talking about Paul and his passion for doing the right thing. But this book deserves, I think, the public's attention because it does sound a warning, a very powerful warning about protecting the financial system and the nation's businesses from the threat of fraud, because this country benefits from having the capital from around the world flow into our markets because they're perceived as honest and transparent. And if we don't have effective enforcement, we may lose that. Jesse, I want to thank you for joining us today. Jesse is going to be outside here in the lobby with book signing. Copies are available out here, and he will be available, I think, to chat with you about your interest in this. Jesse, thanks again for joining us.
Thank you so much.